Hello, everyone in the Zoom audience. I'm Terry Maggedy, chair of our Elder Law Committee of the Trust and Estates section. And the first thing we do for our program is, besides just reminding everyone that now, I used to remind everybody of some other materials, but in your links, there should be a link to the program materials, and you also should have gotten an email with program materials. But the first thing we do is turn it over to our sponsors, because they're what helps us make everything happen. So our first sponsor, Nancy Sanborn, Brian Joy, and the Sanborn team.
Hi everyone, I'm Nancy Sanborn, and with my partner Brian Joy, we'd like to thank you for your continued support throughout the past 14 years that we've been sponsoring the bar.
We'd also like you to know that because we have a far-reaching network of team members, we're able to take referrals of property sales all around Southern California, and some even outside the state.
Thank you for your time, and we really hope you enjoyed today's meeting. It sounds like a great topic.
And our next sponsor that we'll hear from is adage and Geffen Real Estate.
Thank you, Terry. Over the years, I've handled hundreds of evictions and cash for keys situations. Our best practice when there's an occupied property where rents are not being paid is to facilitate cash for keys so we can sell the property vacant and maximize on the return of the sale for our clients. CFK is especially important now. Even though you can file an unlawful detainer, the courts are not making UDs a priority. Given COVID-19, it's unknown when your hearing will take place. Each situation is different. An adventure of sorts. Compassion and kindness go a long way. Cultivating rapport with the occupants and gaining their trust and cooperation. You can have an experienced agent negotiate cash for keys on your behalf. Otherwise, you risk leaving money on the table. CAR, the California Association of Realtors, provides its own cash for keys agreement for the realtors to use. If any of you need help to sell a property and need help with cash for keys, feel free to text or call me anytime at the number here on the screen. Back to you, Terry.
Thank you, Ari. And I'd also like to thank our other sponsors, Marsing Klein with Glen Oaks Escrow. Also, they specialize in the areas that we deal with, escrows for probates, decedents estates, trusts, conservatorships, the special issues with older people, all sorts of complicated escrow transactions that we deal with in our practice in the elder law and probate world. And finally, I'd like to thank our sponsor, our fourth sponsor, which is California Title Company. Also a title company that deals in our areas, probate, conservatorships, trusts. So thank you, California Title Company, for being the sponsor. In addition, thank you very much to all of our sponsors. We appreciate you. And next is, I would like to mention our coming up program, which we don't have anything in December so far, but we do have something in January. January 14, very interesting. Program title, Creating the Village, a cutting-edge housing model for disability inclusion and community building. And our program speakers are going to be Kathy Gott, who's a government benefits specialist, we'll call her, who's been a leader in developing this it's actually a mixed use development that's going to be for all the real estate people here, right next door to Pico Robertson. Really a one of a kind. And also Dana Sales, who is the planning consultant on the project. So they're going to give us a behind the scenes look for this very unique mixed use project that's going up right in the heart of Pico Robertson. Should be that's a very unique program, and it deals with disabilities, inclusion, and those sorts of things. A scheduled break ground, I think, later next year in 2021. And now for our speaker today, which just it seems like all of our programs, we have these wonderful niche topics. You know, thanks to people like Matthew. I've been doing this a very long time. I can tell you, we've never had a program like this before. Matthew Kaplan, our speaker, partner in Tucker Ellis, co-chair of the firm's food, cosmetic, and dietary supplements practice. Is that a niche area? And you'll hear more about what he does by just hearing, the presentation today. But he counsels companies on litigation avoidance, strategies regarding that, supply chains relationships, regulatory matters, consumer class action lawsuits, very interesting stuff. And our program today is food, drugs, cosmetics, dietary supplements, advertising, and the special legal rights of senior citizens. So with that, for the next probably like 15 minutes, I'll turn the program over to Matthew.
Hey, thanks a lot, Terry. All right. Briefly, I was asked as we were chit-chatting before I got on, and it was interesting. Someone asked me, how did I get into this area of practice? And I think Terry's right. You'll learn what I do as I go through the presentation. But the real answer is I've been a litigator. I've done 8 years of environmental litigation back when I was an environmental crimes prosecutor. Back when I was in big law, I did a lot of unfair competition and class action defense. And one of my firm's larger clients back at the late 2000s got involved with some of the class action claims that were starting over food labeling and natural and these type of things. And I found it fascinating. And when I got deep into the regulations, I was like, this is something that I can really use to counsel companies and advise people on what they can and can't do. And I represent from startups to publicly traded companies. Of course, publicly traded and larger companies have in-house people who do their litigation avoidance. So I do the litigation for them. The mid-market and smaller companies are who I talk to. And I am going to try and get my screens to start switching. And I will say today's the first tie I've put on since way before COVID. So that was sort of refreshing. And we'll get into it. If you have a question, type it into the chat room. I'll address it or try and get it at the end. So who regulates consumer advertising? That's really the question out there. And people don't necessarily put all the pieces together because it's the government, all the myriad agencies we have, from consumer product safety to the FDA to the EPA. But you have your local attorneys generals, your courts, consumer class actions, and some private entities like the NAD. And I will talk about that as we go through the presentation. But with regard to senior citizens, and I think this is really important. You all can see the statistics I put up that I did some research on. I'm going to highlight a few of them that I found fascinating. People 60 and over are already a billion people, essentially, 900 million, that's rounded. In 10 years, it'll be a 1.6. In those same 10 years, people 65 and older will be more of them than there will be children. In the US, 50 years and older contributes $8.3 trillion to GDP just a couple of years ago. That cohort would be the world's third largest economy on their own. And along with all the money that they spend, like every consumer, they make their decisions based on messaging they receive. But they are 60% more likely to report losing money in a scam. Why that is, maybe the nature of the elderly and they'll trust government, or something else, but it has a huge impact on senior citizens. So when you get to regulatory issues that we're going to talk about, I'm starting with the FDA just because it's a good introduction for the program. But the primary entity is the FTC, the Federal Trade Commission, because they regulate all advertising. For the FDA, senior citizens are particularly large consumers when you're dealing with supplements, dietary supplements, cosmetics. Everyone has food. And the primary concern of the FDA, as I've highlighted, is safety, misbranding, and labeling. And there are specific rules and labeling requirements for every category. And by category, I mean if it's a food, if it's a cosmetic, or what have you. And these are some of the categories that you will see. Nutrient content claims or health claims that you see on food. This is all on foods. Those are FDA approved. You can't make them without FDA approval. We all know the nutrition facts box. That gets you there. The most important thing in this area is really the definition of drug, which is the second bullet point. If something is intended for use in the diagnosis, cure, mitigation, treatment, or prevention of disease, or intended to affect the structure or function of the body, then it's going to be a drug. And that applies to dietary supplements and devices. We'll talk about that a lot. Cosmetics are what you use to cleanse, beautify, or change your appearance. And the focus, when I say is often the intended use, it actually is the intended use. That was the most amazing thing that I learned when I got in this area, that it's what you say about a product that determines what it is, not its plain formula. So you could actually have the very same formula and you could sell it as a drug, or you could sell it as a cosmetic based on what you say about it and label it, depending on. So the USDA, I'm not going to spend a lot of time on this, but I know it's a lawyer's presentation. So the most interesting thing to me is that the USDA pre-approves labels and packaging, and they have a different preemption scope than FDA regulations. So if you are generating meat, poultry, eggs that is regulated by the USDA, your label is going to be pre-approved and you're going to be able to prevail on a preemption argument, ideally on a 12b6 or motion to dismiss or not. The other interesting thing is that if you take a soup that has more than 2% cooked meat, your chicken noodle soup, now it's USDA regulated and not FDA regulated. And they both use the same nutrition facts, but the legal consequences are different. So let's move on to the fun stuff. The FTC, as I said, they regulate everything. Advertising must be truthful and not misleading. So in other words, you can present the truth, but do so in a misleading way and get into trouble. And before you say anything, any claim about any product, you must have a reasonable basis for it with substantiation before you make the claim. We're going to go into the details of it, but you have express claims, you have implied claims, you may make a comparison between Coke and Pepsi, other various claims, and you have to have a reasonable basis beforehand, which often means competent and reliable scientific evidence to support whatever you're saying. What the FTC, the FDA, courts all look at is the net overall impression that is created by the advertising and the advertising activity. So that's going to be not just the one ad in isolation, what else accompanies it, because we have to figure out what you intend to say and whether your claim has substantiation. The consideration is always how the reasonable consumer would read and perceive the product claim. If you're going to have a qualification or a clarifying statement, it has to be clear, conspicuous, and helpful. We all see them on the infomercials or advertisements with the fine print on the bottom, and they go through it super quick. You know, that's not necessarily going to be helpful or provide you a defense to anything. The thing I find interesting about the reasonable consumer test is it's an objective standard. But I wonder about how changing demographics affects that. And this is an area with the senior citizen population growing. Is it their perception? Is it just going to be an issue that the jury's going to see the issue different? Or is it really going to have a different standard in senior citizens if they're evaluating gaming or gaming apps or something? I just think it's an interesting interplay. FDA and FTC, as I said, there's some overlap. There is primary responsibility for all advertising except for prescription drugs with the Federal Trade Commission. The FDA is primarily responsible, as I said, safety earlier, but when you get into claims, it's misbranding, labeling, or false advertising for the prescription drugs. Tons of overlap. They try and coordinate themselves. The government does try and be efficient from time to time, but you'll see when we go through the FDA's definition of labeling, there's a great deal of overlap. You also have to worry about attorneys generals and local law enforcement. They generally just do false advertising or generic consumer perception or consumer protection enforcement. But we have in California many active district attorneys. They use the unfair competition statute, Business and Professions Code 17200, in order to bootstrap, and will often do the very same thing that the FDA or FTC does. And what's fascinating in a false advertising lawsuit, when I talked about you have to have prior substantiation for your claim, that's absolutely the truth. And the government can force you to turn over or respond to your prior, or ask for your prior substantiation and come after you if you do not have it. Consumer class action lawyers have a little bit different hurdle. You cannot be demanded by a private party to prove your claim that you have prior substantiation. If they're going to be the plaintiff, they have to have an affirmative false advertising claim where they prove falsity. And I know in the trust and estates and the elder law area that you're mostly in probate court, you're mostly in state court, not necessarily federal court. These claims we can often get into federal court, and with the Twombly and Iqbal standard of pleading a plausible claim to get into federal court, it can be very hard for a plaintiff because they have to plausibly allege the falsity. They just can't claim I was misled. Often these class action plaintiffs will go out and do their own studies or testing of products to get you there. The other thing that is a fascinating area in the advertising world is private regulation. The NAD, the National Advertising Division, is part of the Better Business Bureau. They have some sister groups, the Children's Advertising Regulation Unit and others. What they do is privately do what the FDA and FTC does, which surprises people, is all of these entities, they scour the internet, they pay attention to what they read or see on TV, and they will investigate claims based on if they see there's something wrong. Or the NAD will adjudicate disputes, generally between larger advertisers. I'm trying to encourage a lot of business clients to consider the NAD. NAD last year was about a $15,000 fee to get them to adjudicate a claim, which in the context of litigation is quite inexpensive. And what they will do in a private hearing is they will evaluate the science, the studies, the claims that underlying these issues, and then make a ruling to suggest you either discontinue the claim or stop using it. Now, of course, a private entity can't enforce what it does, but they have a very large staff, they're very well funded, and the lawyers who work for and adjudicate matters for the NAD, they're very close to the FTC. Many of them have worked in the FTC before, and vice versa. There's a little bit of in and out between the two groups. There are some different perspectives on things, but a referral to the FTC by the NAD for not complying with their recommendation really gets attention from the FTC enforcers. So it really does pay to pay attention to what the NAD is doing. Going on, the plaintiff's bar. Now, one thing that I think differentiates me and my firm on dealing with regulatory issues is we think about the plaintiff's bar. We've actually gotten a number of clients. We all had clients from our competitors, but we've had clients and other matters come in because regulatory lawyers who spend all their time dealing with the FDA and FTC, they tend to think that that's the entire world. And the reality is the plaintiff's class action bar is a regulator too. The reality is for smaller and mid-sized company, your customer in your supply chain is your regulator. If you want to get your product on the shelf of Walmart or Whole Foods or Target, you've got to comply with their advertising and claim standards. So there's lots of regulators you need to think about, but the class action lawyers are the worst because all they want is your money. They watch what NAD does, what FDA does. If they issue warnings, issue opinions, they just piggyback on it. And they're really important in the senior citizen context. Not many people are aware that the Consumer Legal Remedies Act here authorizes a bonus. It's a $5,000 bonus if the court makes a number of findings related to senior citizens. Under the CLRA, you get to recover damages and attorney's fees anyway, but a $5,000 bonus is a good deal. If it's brought as a class action and you get a class representative who's a senior citizen, every member of the class can get an extra $5,000. So it's quite a lever, and it's, you know, what you need to be concerned about is what's the plaintiff's bar going to come after. So let's get into the meat of the subject. The FTC. So they regulate advertising. Section 5 of the the Federal Trade Commission Act prohibits unfair and deceptive acts or practices. Section 12 directly goes to false advertising that is likely to induce purchases. As a practical matter, the issues collapse onto each other in terms of the standard. But again, the focus is on all claims you make about your product, express or implied, omissions, if you omit material facts, side effects, dangers, things of that nature. Again, you evaluate the overall impression created by the ad. And that's going to include the entire ad campaign very often. It's not going to go digging through you with a fine-tooth comb over everything you say about the product. But if you've got a new campaign promoting a certain theme, you bet they're going to look at all of that. And the entire test under the Federal Trade Commission Act, and this is actually true under state law in virtually all jurisdictions, is how does a reasonable consumer read and perceive the product claims? What are they thinking? The FTC also does the Fair Packaging and Labeling Act. This is how come we always know who makes our product and what the ounces are that you see on the bottom of the principal display panel. California state law has a lot of overlap in their own independent statutes on the same thing, but that's the general nature of their authority of the FTC. It's consumer protection. We talked about unfair acts. Those cause or are likely to cause a substantial injury. They're not reasonably avoidable by the consumer and not outweighed by countervailing benefits to either consumers or competition. What's deceptive? Again, is going to mislead consumers acting reasonably under the circumstances. The FTC does not have to establish an actual injury. They can get injunctive relief and other penalties, and they often go after that. Consumer class action plaintiffs, whether they're pursuing federal or state court, well, you need to have an injury. That's called standing. So you do need to be worried more broadly about the FTC's tools, but it's the same issue. Are the claims material to your purchasing decisions? This advertisement from Wiley, to me, really says it all. This is where you're going to go when you're dealing with an ad. Eating chocolate makes you look younger and thinner. Wouldn't that be the case? This gets us to what's required for your claim. Substantiation. Before making your claim, you have to have a reasonable basis, which means you have to have at least the amount of evidence that you claim. If you're going to claim 4 out of 5 dentists prefer a certain chewing gum, well, 4 out of 5 dentists better prefer that chewing gum. And it's got to be to a level of experts in the field would agree is reasonable. So it's not going to be just a poll of 5 dentists down the street on Ventura Boulevard. It's going to have to be something that experts in the field might believe is statistically significant. Do you have a large enough sample size? How many people have you polled? If you're going to be dealing with something beyond a preference of taste, something that's technical, competent and reliable evidence, or competent and reliable scientific evidence. Your substantiation that the level is needed, people always say, what do I need, is claims driven. What do you want to say? The stronger the claim, the more rigorous that you need for it. And the smaller clients that I work with, people new to the area, this is very frustrating. People often say to me, gee, that's my marketing hook. Why are you trying to tell me I can't say that? And of course, my response to that is, I'm just a lawyer. I'm not telling you what you can or cannot say. I'm just telling you that there's risk and these are the requirements. And if you want to say that eating product X is going to do Y, cure cancer or something else, that might be a great hook. But if you don't have scientific studies for it and you don't have your FDA approval or anything else, you're just selling snake oil. So it's a challenge for people who don't understand it. Everyone always asks me, well, gee, this is puffery. It's just, oh, it's the best product, so that's just puffery. Well, puffery is a lot narrower than most of us would think. It has to be something that is not capable of proof. And the NAD and then a follow-on class action a number of years looked at claims about computers and computer performance that said the best performing computer. And it was related to a speed component. Well, it's not puffery to say best performance related to speed anymore. Now you're making a statement of fact about that speed. You better have compared it adequately with enough studies to enough competing products. So it's really best tasting, but it's not going to be preferred by pets or preferred by dogs, because you can actually test kibble amongst dogs and see which one's preferred. All right, competent and reliable scientific evidence. This is generally referred to by FTC as adequate tests, studies, research by qualified persons with appropriate expertise in the field, performing their tests in an objective manner with procedures that are generally accepted in the field. This is the big challenge. We had a client who had a supplement that improved performance and had some tendency to make people feel, men in particular, feel better. And they ran their studies and had about 25 volunteers added to their diet. And they then wanted us to justify and support their use of the claim for the supplement that they were selling. They had two problems: that the 25 volunteers had been testing and using the active ingredient in its natural state from a plant. It was then subsequently processed, that active ingredient, so it can be distilled into a capsule. And you don't have a fit on your results when you say you're studying the plant form basis, and now you have it in a capsule with other ingredients that may or may not interfere with its reaction in the body. The second problem you had was these volunteers were all living in India, and they were all presumably vegetarians in the part of India that they came from. And that's not a fit or an appropriate study for a supplement you want to be selling to Americans who have a very different diet and are a very different basis. So that gives you an idea of the type of things that you have to think about. High quality control tests are needed. The more specific, the more your claim is, the science, it's got to be there. I just talked about ingredient versus product testing. You got to match your dosage. If you're 10 milligrams of the active ingredients, what you test, and then you're only selling 3 milligrams of the active ingredient in your supplement, that could be a real problem. Palm Wonderful back several years ago had a number of, they litigated all sorts of false advertising issues, many of which they didn't succeed on. But they did take up the FTC's attempt to require them to have 2 placebo-controlled studies to support their claim. And the Supreme Court said, no, it's just 1 or more. It's a reasonable basis. They were selling the pomegranate juice. It wasn't a drug. It didn't need to meet a higher standard. That was a loss for the FTC. Along these lines, you got to talk about your comparative claims. Rice crackers that are 40% less fat than Slim Jim, that just doesn't fly. That's not a claim that's going to have any meaning. The Campbell soup case, it was brought as a class action, 25% less sodium than regular condensed soup, but the less sodium version had the same amount of sodium as the Campbell's regular tomato soup and cost 50% more. So what was going on there? Campbell's was defending itself saying, well, when we said 25% less than regular condensed soup, it meant all condensed soup, not just tomato soup. They did change their advertising after they got sued, and there was a confidential settlement. So we all can, make the inferences and draw the conclusions that we think will come from that. Disclosures. Clear and conspicuous with our 4 Ps. Prominent, presentation, placement, proximity. You can't hide your disclosures on the back of the box. You can't hide them in the bottom of the web page. It's always a challenge. I've rewritten ad copy very often to try and make things more prominent because you have a real estate challenge when you're dealing with advertising. Disclosures cannot cure false claims. Senior citizens, I think this is a big deal. You have false headlines all the time. If you read the fine print, whether it's an advertorial that you'll see online or in a magazine where it's paid content and it kind of looks like it's an article or something like that. I know that I've litigated cases and there have been standards about misrepresentations on the front of the product cannot be cured by what's on the back of the product. That started in a food context with the Gerber v. Williams case. I litigated a subsequent case where we said no trans fat on the front of a product, and on the back of the product, we reported in the nutrition box that it had 0.0% trans fat, and we were required to say that by the FDA because they have a mandatory rounding rule that if you have less than half a gram of trans fat, you shall express it as 0. So we had 0.0, and we got sued over all sorts of claims, went up to the 9th Circuit, and won on some claims, lost on others. And the 9th Circuit felt very much that no trans fat is different than 0.0% trans fat. And my client was admitting it had trans fat in it. So this was a false and misleading statement. And there you go. And of course, defendants always write, well, I told them the truth. There I was buying my new car and I had been told my financing would be X, Y, or Z, but I'm with the financing department and they're changing all the terms. That doesn't work. That's false advertising. You can't fix your problem. In this arena, the FTC itself is not going to take on subjective claims, opinions. Those might be puffery anyway. But people have to be careful. If you have a celebrity, and these cases have come out, who's promoting a product, and they say, I use it myself. Well, that celebrity better use it themselves. And that's a problem not just for the company that paid the celebrity, that's a problem for the celebrity. Because it has to be an honestly held opinion. People are going to make the reasonable consumers going to think that it's true. You can't misrepresent the qualifications of who's making the statement. That's why you always see person in a lab coat portrayed by actors. When you do have experts, though, you put somebody in a lab coat or have a doctor talk about your product, the FTC and others are going to say, now you're making representations of fact. Even if the expert's just saying, I think this is the best such and such, the reasonable consumer is going to believe because of the expertise that that's a representation of fact. So what can the FTC do? Well, they can do a lot of things. Require corrective advertising, issue cease and desist orders. They can force you to stop using your brand name or get out of the business altogether if no other means are possible. They generally focus on restitution or redress to consumers. There's been a lot of action over 13B of the Federal Trade Commission Act as to whether or not it authorizes disgorgement of profits or ill-gotten gains. For decades, it has been assumed to, and settlements and cases have happened. But a few years ago, some of the courts of appeals have started questioning that. and it is now up on this term's Supreme Court docket. I predict that disgorgement will not be an available remedy anymore for the FTC, but that's just my read of what the court is doing. The FDA. So as we had mentioned, they deal with food, drugs, cosmetics, their category material. Their primary concern is unsafe or deceptively labeled or packaged products. Unless you're dealing with prescription or over-the-counter drugs, then you have a safety and an efficacy problem or issue, because obviously we all hear about it now with COVID. The product's got to work if it's going to be a drug. But in the more generic consumer product area, the FDA focuses, is the product unsafe or deceptively labeled? I mentioned the Nutrition Labeling and Education Act because that has required standardized rules and preempts inconsistent state law claims. I mentioned before, USDA does have a role in food, so it's not to be forgotten about. So two things here. People will probably wonder, gee, why has he got Hormel chili on this slide? Well, I've done this presentation or a version of it before with my client at Hormel and made them happy to use their photo. And I wanted to have a food, cosmetic, some supplements over there. And the most interesting thing to me, we talked about it before, is what you say about the product defines what the product is. It's not what the product does. It's not what the product has active ingredients about. It's what you say. So if the article is intended to be rubbed, poured, sprinkled, or sprayed on or introduced into the human body for cleansing, beautifying, promoting attractiveness, you're a cosmetic. If you're going to do something to diagnose, cure, mitigate, treat, or prevent disease or affect the body, you're a drug. That intended use is critical. So getting back to labels and labeling, that's what the FDA focuses on. Label is what you think about it. Written display of graphic material accompanying the article. But the regulations and actually the statute defines labeling anything else accompanying it. And you see Skippy peanut butter, another shout out to my client, Hormel, that's a Hormel brand, had peanutbutter.com on the packaging. That makes the website part of the labeling. Everything on the website is now under FDA's jurisdiction. Without that there, the website might not have been part of the labeling of this item. It might have just been a false advertising issue. So they are worried about misbranding. The basic test is similar to the FTC test. Is the label false or misleading? Again, like general false advertising, misbranding can be express or implied or by omission. All the states use the same standard. It's really effectively, in practice, the same thing as the false advertising, likely to deceive the reasonable consumer, acting reasonably in the circumstances as the standard. But the law and the case law speaks in different words, as us lawyers sometimes do. There's a whole slew of things that'll make a product misbranded, according to the FDA. Some of the more interesting ones is the form of your packaging. We'll get to slack fill, imitation of another food. It could make it misbranded. Number 7 is fascinating to me. I learned about standards of identity back with that butter substitute. Butter is defined according to FDA. It has to have a specific characteristic. Mayonnaise, other types of products. There was, I don't know if you guys have your clients do this same thing in your areas of practice as mine can sometimes. Best Foods got a lot of bad press, I thought, or press 4 or 5 years ago when they sued Veganese, and I think it was Just Mayo, because they were imitation mayonnaises. They weren't made with eggs and oil, and because they were vegan. That kind of backfired the PR, but they were technically right, and us lawyers sometimes make those mistakes. So interesting things happened there. How do you establish intent, whether it's the FDA or anyone else? Well, you got to take a look at what's the overall messaging that you sell. And you're dealing with supplements and cosmetics. Often ingredients are included that have well-recognized therapeutic uses. And if you're advertising your supplement and prominently promoting the ingredient, that's going to lead FDA, or may lead FDA to draw the conclusion that you intend this to be a drug. You think the public knows that this ingredient does X, Y, or Z, and that's why you want to talk about it so prominently. Consumer perception is critical. We work with consultants and experts who do consumer perception surveys all the time. The internet has made it a little bit easier. Those studies have to be properly done, and you can either use in defense or in the offense to support the claim that no, it's not creating an impression that this product's intended to be a drug or to treat disease or change your subject matter. You'll also use consumer perception to show that consumers are not likely to be deceived. And I handled one case where we had actually dealt with a protein powder that we got sued. And the claim was when we said that the protein powder had amino acids to help build lean muscle mass, that it falsely implied that drinking this protein shake would help you get lean. And we did consumer perception studies and a lot of money spent to, we said, no, lean muscle is actually a biological thing. And people who consume these products in the weightlifting field, the exercise field, understand that when you're talking about amino acids promoting lean muscle development, they're talking about that, not a diet product. Like so many of these cases, like every case, we never really got to decide who was right, despite our studies, because we settled the case. But it's really interesting, and you need to be careful with your products. So some examples here. We'll go through different aspects of, what these cases are about. Here, it's the net overall takeaway. Vignettes can come better, come together, do two or more claims, imply something else. The Graduates was a case that was a problem for Gerber. These fruit juice snacks were advertised with the pictures of the fruits. There was no fruit juice in them. There didn't need to be under FDA regulations, and all the ingredients, because it was a food, were in the ingredient list. But this sort of went back to you're misleading the reasonable consumer. They're going to believe there's fruit juice if you're calling them juice treats. A little bit about structure function claims. This is really predominantly in supplements. A lot of foods do it too. It describes how a substance affects the normal functioning of the body, help maintain it. The calcium builds strong bones is the most obvious, to me at least, claim. A lot of us hear about that. Fiber maintains bowel regularity. When you make claims of this nature, you may have seen on them, there's mandatory language that the FDA has not evaluated this statement or approve it. I don't memorize statutory language. I look at it again, but it's there generally by an asterisk. Most people tend to put it not in compliance with the regulation because it's supposed to be right next to the claim. And you'll see an asterisk in the bottom of the bottle, but those are the risk evaluations businesses need to take. Here's some examples of the difference and how you can cross that line between a drug and structure function claim without necessarily knowing it. Fiber maintains bowel regularity. That's great. Treats or cures IBS. You can see how that's a drug claim. Prevents heart attacks. That's a disease. So you got to be real careful and evaluate these things, whether it's labeling, advertising, or what have you. There are products with shared characteristics. Antiperspirants, sunscreens, anti-dandruff. These are all drugs. Obviously, an anti-dandruff shampoo, you're using that to wash your hair, but it's technically a drug because dandruff is a condition of the body. And there is requirements. If you're going to make an anti-dandruff shampoo, you got to register with the FDA and deal with it like it's a drug. And your claims cross over in the area. Sunscreens are very frustrating. Senior citizens use tons of them. You should all use them. Everyone should use sunscreen. The FDA is behind the times. We don't have the best sunscreens in the world because changing drug standards requires a Herculean effort to support with studies and get FDA approval. You find this mostly, this is an FDA statement, cosmetics that promise too much. There are tons of cosmetics all over the place that promise too much. Skin conditions, increase collagen, make you feel more youthful, and they get too far. Regenerative, reviving cells. These are all drug claims, and we'll go through some examples when I get there. Oh, devices have the same problem. Senior citizens use, obviously a lot of the devices that have been promoted, whether it's dermabrasion, fillers, all of these things, it's the same issue. FDA, as I mentioned before, they issue warning letters. There's a dinger system. You can sign up, and you too can receive a weekly email from the FDA with a link to all of the warning letters that get issued every week. And those are roadmaps to plaintiffs' class action lawyers. They highlight all the problems just directly. They cite the law. It's beautiful. The FDA can seize your goods. They can have customs, both the FDA and FTC. You can have them impounded as you're importing overseas. We've had to deal with that. They can go to court and get injunctions, order recalls depending on what your product is, which we've had to handle. Unsurprisingly, a very powerful agency. So what are the triggers that you'll see in these claims, in these lawsuits? This is what we generally see. Slack fills down there at the bottom. That's highlighted by the claim and the Lay's potato chip. We'll talk about that a little bit more in a moment, but we've seen cases, dozens of them in all these areas. The consumer class action lawyers come on. They use that Consumer Legal Remedies Act that I talked about. They get their extra penalties. They use the false advertising and unfair competition claims. Statutory warning issues are out there with California Proposition 65 that we deal with a lot. It's really only limited by the creativity of the plaintiff's bar, so it's really unlimited. Natural's always drawing attention. I have clients, even today, I can't believe it, who want to name things natural. Natural is undefined, except according to the FTC. In 2016, they issued 4 settlements at once, had a big press release. It's essentially become a rule through administrative adjudication. All natural or 100% natural. These are establishment claims. Obviously, if you're going to say 100%, it better be 100%. No artificial ingredients or chemicals. They did studies, Apparently, the reasonable consumer does not perceive all natural and natural to be the same thing. And according to the FTC, there was no evidence that consumers expect a natural product to have absolutely no synthetic ingredients or chemicals in it. Of course, if you're making these claims and don't have substantiation for them, then you can get into problems. The FDA has been asked repeatedly for decades to issue a definition. 5 years ago, they opened commenting and asked what they should do. And 5 years later, they've done nothing. Arguments are all over the map. Some say, of course, well, if natural, human beings invented it, human beings are natural, the invention's natural, everything in nature, or you get the FTC position. So it's unsettled. USDA has a stricter line, again, a little bit better enforcement authority or regulatory authority and preemption. They don't want your meat to have any artificial flavor, colors, chemical preservatives. Of course, if you can submit a label to the FDA and get the USDA and get it to approve your label with the word natural on it, then you're fine because other claims, state law claims, will be preempted. I mentioned the NAD, they generally follow the FDA and FTC. NPA is interesting. It's illustrative here. This is the Natural Products Association. If you remember, they have a multi-tiered approach. They define what you can include in it. Like many standards groups out there or trade organizations, you can put on your label that you're NPA natural and try and develop that that's a better certification. There have been a number of lawyers who've been trying to export through litigation these standards, whether it's NPA or others, and to say that trade group standards should be enforced under the unfair competition law. Some of the cases got past motions to dismiss into discovery, got settled. There hasn't been any real trials on that, but that has generally not gotten traction. There's been a couple of opinions that there is no legal requirement that you meet a trade group expectation. What gets targeted? Everything gets targeted. If you're going to say natural, and it gets, to me, that's important is stuff like alkalized cocoa or citric acid. How do you get it? Obviously, you can get citric acid from citrus juices or other things, but if you're buying a commercial grade and it's made differently, claims have been asserted. And I always tell my business clients, not always, but often, gosh, you got a demand letter, you got a lawsuit. Seems to me that you've already lost because now you're spending that money. GMOs have been an issue. They've gotten around it. Here's some examples. Trace Amain Naturals of what the consequences can be. $3.25 million of a settlement. The attorneys got $1 million of it. $5 a product to the class members. They got an approved incentive award to the named class of $15,000. And they stopped selling this line. Another one, Tom's of Maine. This is an illustration of where the NAD had was the tip of the spear, had investigated the natural claim. They recommended changing the all natural label. Class action plaintiffs came in afterwards and piggybacked on that. They made further disclosures. Attorneys made $1.5 million. And consumers, if you had a proof of purchase for up to 7 of them, you could get $4 back. Naked juice. You can see I've highlighted with the black circle, the all natural fruit, non-GMO, 100% juice. Here was the point before. Synthetic vitamins and minerals were added to boost the nutritional level. $9 million settlement was a chump change to Coca-Cola, which owns Naked, but still not chump change to the brand and how they account for that in-house and the bonuses of the staff. So Truvia, same problem. It's a stevia sweetener. It was the processing that got it into a settlement of $6 million. Not a slack fill. Slack fill is the difference between the actual capacity of the product and what you can see in it. Here's some examples. I think fascinating to me, the McCormick, I have them on there twice, but the cans, you can see that the black pepper went from 8 ounces to 6 ounces of product, but they didn't change the can. This is how they can raise prices. And some lawyer noticed it and was able to bring this as a slack fill claim, and they did well. The one in the pepper mill is interesting. I think that issue got highlighted because there was a change. Generally under the slack fill law, it's a question of non-functional slack fill, and as you can see, where the consumer cannot view the contents. So I'm not sure what happened there. I've had a number of clients who, in our bottling, we redid the label to put some clear sections in there so you could tell what's in the box. To me, the most interesting slack fill case that has happened in ever was movie theater candy. Federal district court judge threw that out, even though it seems to be a heck of a slack fill problem, on the premise that, oh, people have been going to movies. They always know that those containers don't have that many jujubes in it. So that was fascinating to me. What is functional or non-functional? It's not exactly clear, but if you're a business, you got to have a good reason as to why you have your space there. All that space in potato chips is there because it keeps the chips from breaking. That makes sense as a good use. A reusable gift or a container, if it's extra large and it's, a fancy vase that comes with or something, that's a good excuse. If you're packaging 2 different items that you're going to smash together, a functional role or combine, that can be an explanation. Just don't mislead the consumers. Pretty straightforward. Here's some cases. Slack fill was a big deal to some of the task force of DAs in California. They got together on this Olay product that changed from a plastic container to this, and I've seen it, this really surprisingly luxurious looking glass container. But it was very heavy and it misled you as to the amount of product. $850,000 in penalties there. This fresh case over the lip balm, the Ninth Circuit said, well, gee, a lip balm in a tube, no one expects to get all the lip balm out of that. And the claim in this one wasn't as much as a slack fill as it was like in the very bottom and the plastic that sticks to the screw. To me, that was remarkable. Again, the court saying no one expects that. The other remarkable fact is, yeah, 4 years ago, there was a lip balm that cost $24. Here's some examples of FTC enforcement actions. You're dealing with, a cosmetic or a soap, a lotion, yet FTC got involved. They said they were trimming thin waist, stomach fat, cellulite fighter. I mean, it's surprising that companies of this size would make these claims, but the marketing department does not always check with the in-house department and the department of no. And, those claims get some traction in the marketplace. L'Oreal was a real big deal. This was FTC. There were definitely drug claims in here. For 20 years, there is an injunction that governs L'Oreal's advertising of a number of their products. The reasonable consumer was here. You look down, it says crack the code to younger acting skin. Well, that might not really be a problem on its own, but then they were making claims about the gene science in a new era that's clinically proven. And what's younger acting skin? And you look at the label, it's youth regenerating. Again, visibly younger skin, that's not necessarily a problem. I defended a product called ROC or ROC that actually used to advertise it will take 10 years off your skin, 10 years off your face. And we actually had substantiation for that. The NAD came after us, and we had studies that we had done through consumer perception, using the product appropriately, photographs of the skin, and we asked people to, or my client did, evaluate how much younger people looked, and the claim was legit. B Green had a number of problems from the FDA, just some examples: suffering from eczema flare-ups, made with organic oil. Hail Mary, FDA reviewed the website here. This Miracle Tart dark chocolate would apparently reduce diabetes symptoms and regulate blood glucose levels. Got into drug territory there. The toning lotion is the point that I was talking about before. It's, anti-aging mechanisms that help the appearance of deep wrinkles. Typically, if you say it gets rid of the appearance of wrinkles, that's good. But earlier in the sentence and elsewhere in the advert campaign, they talked about the neuropeptides and peptides sending signals to skin to activate skin. So now it's affecting the structure of the skin. Testimonials, those are a big deal. I wanted to just highlight that momentarily. Tibetan Herbal did what a lot of companies will do. Someone makes a Twitter or they tweet something, how wonderful it is. There's nothing wrong with that. Doesn't have to have substantiation. Doesn't have to necessarily be truthful. So long as the person who's tweeting about it has no material connection to the advertiser, and the advertiser doesn't know the person who's tweeting about it. But when the company takes that tweet and links to it on its website, now the company's adopting everything they say as their own. So that becomes a real problem in social media. We're very busy with that. Some of the settlements, I bring up organics, which is now OGX. Class actions got them to change the name of the brand. The risks are so high. This was, I'll just be another minute or two. This bath time, there actually were clinically proven to help this baby sleep better. This became a problem because the study was really clinically proven that a routine helps a baby fall asleep faster and stay asleep longer. In the routine, they used this Johnson's Baby bedtime wash, so it could go all together, but it was a misleading claim because it didn't fully disclose all the elements of it. Sunscreens I mentioned before, sunblocks, they can become drugs. Waterproof was a problem. I think this is my last one. University Medical, the NAD investigated them, and this really tore apart the studies. The clinical studies had flaws, internal studies didn't have controls, they didn't use the products consistently and document that they were done consistent with the instructions, and the NAD suggested they stop advertising this, and a follow-on class action followed. So, oh yeah, auto renewal, risk-free trials, similar type of issues. You can get into trouble if you don't honor them. Birchbox got into trouble with theirs. There was this other product, Ageless Male. I defended the Ageless Male product. We didn't have a problem. We got a demand letter. We immediately changed what we were advertising. The plaintiffs had no claim. They didn't have standing anymore and dismissed it, but they tried to recover attorney's fees, $75,000. District Judge Lorenz denied them that. It was appealed to the Ninth Circuit. That was denied as well. So it's really how you respond to it and how quickly you deal with it, as well as, what you're doing. Some best practices to think about. We do website reviews, and that gets beyond what you're saying about your product. Your terms and conditions are really important. Not a big fan of arbitration disputes generally as a litigator or as a consumer, but if you're a consumer brand, you want arbitration and class action waivers. You want to make sure that they're not unconscionable, and you want to make sure that all your claims are there. I'm going to stop sharing the screen. I don't know. I saw there were a couple of questions.
And let me just go on, whoops, 1 second. And I may only, first of all, Matt, that was like, that was incredible. I'm sure I'm not the only one. It just opens up a whole other perspective on the legal world, on your industry. And it's one of those things that's great for people in our industry, like elder law, probate, to know about, because it touches us, but it's, as with so many of other things, now we know who to call. That's the motto. But I'm gonna, because it's 1:30 and we've been trying to keep our programs, to an hour each. I'm gonna end it online, but everybody has Matt's information that was posted. I'm sure, Matt, can people just contact you directly if that's okay? Reach out to you?
Absolutely. Happy to talk with people. That's, it's half the point of the Bar Association and other things, to network, get to know new people, and figure out, how you can help them out. So I'd love to take people's calls.
Great. Anyway, thank you. Thank you so much. Anybody out there, if you have chats, questions, comments, just call Matt directly. And for now, we'll sign off. Thank you again.
Great. Thanks a lot, Terry. I appreciate it.
Bye, everybody. Bye.